Hi, my name is Sarah Benson, and I'm a lecturer at the University of Illinois College of Law and a scholar in the area of LGBT rights. And today, I'd like to discuss the Obergefell Supreme Court decision with you. What does it mean, and what does the future hold? First, it means that all 50 states must recognize the right to same-sex marriage, and they must recognize same-sex marriages performed in other states. This overrules the 13 states that prior to the decision held that same-sex marriage could not be performed in their state. But what was the basis for the ruling? As I predicted, the ruling, which was 5-4 decision, was based on the fundamental right to marry and the fact that it could not be denied to an entire group of people, gay and lesbian couples. But it was based on the same logic of the Loving versus Virginia decision, a decision where the court held that a ban on interracial marriage was unconstitutional. Why was the decision so long when the Loving decision was so very, very short? Well, in Loving, there were no dissenting opinions, whereas here in the Obergefell decision, each of the 4 justices who disagreed with the decision wrote a separate dissenting opinion. So, Justice Kennedy felt that he needed to use some time to explain the decision. First, he chose to explain 4 principles underlying the right to marry as fundamental. First, he stated that there was a right to choose who to marry. In other words, in the Loving decision, you could choose to marry someone of a different race, and here you could choose to marry someone of the same sex. He also noted that the right to marry is fundamental because it supports a 2-person union unlike any other right supported by law. So a civil union, for instance, is not exactly the same. Third, he noted that it safeguards children and families like no other rights can. And fourth, he noted that it's a keystone to our social order, and if it is such a keystone, it can't be denied to an entire group of people. Finally, he noted that there's a synergy between the Due Process Clause and the Equal Protection Clause. The Due Process Clause is the clause that recognizes that the right to marry is a fundamental part of our liberty. And the Equal Protection Clause states that different classes of individuals cannot be treated unequally under the law. How can one address the 4 dissenting opinions, Chief Justice Roberts, Scalia, Alito, and Thomas, who think that same-sex marriage and marriage rights in general should be left to the states and should be at the will of the majority? This is exactly the type of case that the Supreme Court needs to address, because the Equal Protection Clause is all about protecting the minority from the will of the majority. How many openly gay senators do you have representing your state? How many do we have in the federal government? And if the will of the majority can trample the rights of the minority, then the Equal Protection Clause would lose all meaning. So what is the future of LGBT rights in this country? I think that the next big battleground is going to be over the Employment Non-Discrimination Act, or rights protecting folks in the area of employment discrimination, in particular transgender rights. We've seen ENDA, as we call it, fail many times because transgender issues were either introduced or not introduced. And I think that in the future, that's going to be the next area for LGBT rights. I hope you'll comment, and I look forward to speaking with you again soon. Thanks.